Horace, veuillez-vous lever. Please be seated.
Before I delivered a ruling of the Chamber on the matters we discussed before the break, I first informed the parties that a decision was filed today to include in the modalities for trial, to that extent it's an amendment to the modalities of trial, to include regular reporting by an independent psychiatrist every 2 months. The Chamber has carefully considered all the submissions made by the parties and reject the request for an adjournment. This decision will be given in writing with all the reasons, but just to give a very summary explanation and the language not being authoritative. The Chamber finds that no objective medical reasons were established that would disable the accused to follow the proceedings, if not in court itself, then at least through a video link. Again, the reasons will be set out in a written decision that will follow soon. The application by the defense was to adjourn the proceedings and to order an examination, a psychiatric examination, so as to exclude for the possibility that psychiatric reasons could oppose against continuation of the proceedings. That, of course, is implicitly rejected as well. That will be dealt with also in the written decision, and as a result of the decision filed today, which you may not have seen yet, but you'll understand that it was not drafted the last 15 minutes. We discussed the matter earlier. That the Chamber expects to receive relatively soon a new psychiatric report. The Chamber has considered how to proceed, and the Chamber would like the registrar to send a copy of the following lines to the United Nations Detention Unit, so that Mr. Stanišić will be informed about the decision by the Chamber, the decision that a request for adjournment has been rejected due to the fact that no objective medical reasons were established that would disable the accused to follow the proceedings, if not in this courtroom, then through a video link, which would also allow for the accused to further consider whether he wants to follow the proceedings from the video room. For that purpose, we will again adjourn, and the Chamber would like to be informed about, once this message has been conveyed to the accused, whether he wants to follow the proceedings through the video link, and as the parties may understand, it will have some consequences for how long sessions would be, how long breaks would be. Therefore, the Chamber would like to be informed, if possible within 15 minutes, about the result of this information to be conveyed to the accused. We will resume at 4:15.
Orais, voulez-vous lever? All rise. Veuillez vous lever. Please be seated.
The Chamber received a copy of an email sent by Fraser Gilmore addressed to the registry, a person in the registry, and I'll read it into the record. First, the name of the addressee is mentioned, and then I have just spoken with Mr. Stanišić with the assistance of a language assistant to avoid any problems of misinterpretation. I explained the situation to him and informed him that the Chamber would like to know if he wishes to participate in proceedings via video link. Mr. Stanišić refused the opportunity. Then it continues, I left a copy of the following section of the transcript for Mr. Stanišić to read in his own time. And then the section starts with the Chamber has considered how to proceed, and the Chamber would like the registrar, which we find on today's transcript, 15 hours, 58 minutes, 41 seconds, up to 16:00 hours 34 seconds, the last words being about the result of this information to be conveyed to the accused. Regards. That is put on the record. In view of the present situation, we'll proceed.
Your Honor,
yes.
May I briefly, before the prosecution starts with its opening, address the court with a request to the Chamber. We humbly request the Chamber to instruct the registrar to, if possible, have the first psychiatric report available timely before the 29th of June. Many of the reasons can be adduced for this, but one of the reasons is that...
Yes, Mr. Knopf, this is a request which could have been easily addressed at another moment and even informally. Let's focus today on what we are here for now, after we have decided whether or not to proceed. And just perhaps for the parties to explain, everything that can be settled without any negative consequences out of court, we should not use court time for that. We are limited in our time, and first of all, it goes almost without saying that, and the Chamber has taken the initiative already, that of course we start to have the first report as soon as possible, also in view of the frequency, but this is not necessarily, and let me just explain to you, we have, for informal communications, there are three different kinds. The one is purely practical, can be exchanged without leaving any traces on the record, such as, are we moving tomorrow from courtroom 1 to courtroom 2? These are matters. If it has some substance, then I'll put it on the record by referring to it in court, as I did, for example, today. And if it's of great importance, then the Chamber will invite the parties to file it. Let's proceed. The message is clear, Mr. Knoop, so therefore...
Thank you, Honor.
Mr. Groom, in view of the fact that Mr. Stanišić has not opted for following the proceedings, this means that we can have the usual court schedules, which means that we have 2.5 hours to go. I would say I leave it to you how to split that up. And if I think it was announced that you need 3 hours, is that?
My best estimate, Your Honor, is that the opening will take 3.5 hours.
3.5 hours. Then we have 1 more hour to go tomorrow. I leave it to you where to have the break. We are relatively flexible in view of the time. You may proceed.
Thank you, Your Honor. Your Honor, before I begin, I will be showing different evidence and other documents on slides. If the Chamber and all parties in the court would so kindly press the e-court button, they'll be available. I would also ask at this time if the court usher would distribute to the Chamber and to the defense a copy of those slides. It may be that I move past one before you've had a full opportunity to read it. This way, you will be able to fully grasp or digest what's on each of the slides. And I'm providing defense 2 copies each, one for each accused and one for lead counsel. Your Honor, I'd like to begin my opening with the words of Mr. Ivica Stanišić himself. Quote, "We are now entering the decisive phase of the fight to achieve the common goals of all the Serbian lands, more determined and prepared than ever before." End of quote. These are the words of Mr. Stanišić in a telegram he sent to the Ministry of the Interior of the Republika Srpska Krajina in Knin in July of 1994. This case will be an exploration of the quote, common goals of all the Serbian lands, close quote, referred to by Mr. Stanišić in his telegram. Specifically, what were those goals? Who shared those goals? What were the methods employed to achieve those goals? And most importantly, were international crimes committed in pursuit of those goals? Perhaps one of the most shocking pieces of evidence adduced at a trial in this tribunal is a video containing images of 3 men and 3 boys, shot in the back, hands bound tightly with wire. Captured as they fled a fallen Srebrenica, we watched them silently and with resignation walk to the spot where they are murdered one by one. We watched their captors, some mocking the 6 in their final moments, others demonstrating a demeanor more akin to a routine task, one focusing on capturing the executions on videotape. Here on slide number 3, we see the youngest, Dino Salilović, moments before he is executed. The world recoiled as the image was played repeatedly on news programs. The day will come in this trial when we will have to watch their death again, but not today. Today, I want to show you a different part of that video. The video taken that day is approximately 2 hours long. The parts of the video that I want to show you this afternoon, while at first appear less shocking, upon reflection are more disturbing than the killings themselves, because they reveal that the perpetrators of these crimes were not rogue paramilitaries, not a band of common criminals. Though the perpetrators of these crimes and the other crimes charged in this indictment were a well-organized and equipped group, part of the special units of the Serbian DB, the State Security Service of the Republic of Serbia. Members of a unit that was well-trained, well-equipped, well-paid. They had everything they needed, including a license to clear land of unwanted peoples, a license to murder. What is now known about the special units of the Serbian DB has left many Serbs wondering how it was possible that some of the most grievous crimes committed during the war were committed in their name by men paid by the government, men in a unit administered by the State Security Service of the Ministry of Internal Affairs of Serbia, more specifically by Jovica Stanišić and Franko Simatović. Your Honors, this case in its simplest terms is an examination of the conduct of two of the people with primary responsibility for organizing, training, funding, equipping, and directing members of the special units of the Serbian DB to perpetrate grievous crimes on the territories of Croatia and Bosnia in the name of protecting Serbs and securing for them a land free from Croats and Muslims. Not too long ago, a Serb journalist posed the question in reference to the special units of the Serbian DB. Quote, "How did it happen that a group of armed and dangerous men dared to shape the destiny of an entire nation?" Close quote. Can I draw your attention to the video playing now in slide number 5? Here in 1997, Mr. Stanišić and Mr. Simatović celebrate their work, forgetting the suffering they occasioned, while they pose with current and former members of their special units. The proud founders of that group of armed and dangerous men that so dared to shape the destiny of an entire nation. The tensions that fueled the breakup of Yugoslavia and the terrible inter-ethnic violence that spared no one are still a subject of scholarly and popular debate, a debate that lies outside the task that the trial chamber begins today. The trial chamber is not called upon to adjudicate these issues, and I will spend little time on them here. The focus of this trial is upon Mr. Stanišić and Mr. Simatović and the role they played in the commission of crimes in Croatia and Bosnia and Herzegovina. The role they played in a plan to use violence to forge fundamental demographic changes on the territories of the former Yugoslavia. It is only right that we begin this task by spending a few moments to consider who these two men were at the outset. What were the legal duties and what were the boundaries of their authority? Both Mr. Stanišić and Mr. Simatović were employees of the Ministry of Internal Affairs of the Republic of Serbia. I will refer to this ministry throughout this opening by its Serbian acronym, MUP, or MUP. The Serbian MUP's mandate is articulated in the Serbian law on ministries, which is reproduced here in relevant part on slide number 7. Its legal authority is similar to other interior ministries in other developed democratic societies. In essence, it was responsible for the protection of citizens and residents of the country and the regulation of borders passports, and identity documents. In short, the Ministry of Internal Affairs, the Serbian MUP, was responsible for the safety and security of persons inside the Republic of Serbia. One of the administrative divisions of the MUP was the State Security Service, the part of the MUP headed by Jovica Stanišić. This section, too, was more commonly known by its Serbian acronym, the DB. Slide number 8 shows Article 3 of the DB's rules, the article which defines its mandate as one of collecting information, data, and knowledge. Information of general and counterintelligence. Information concerning extremism and terrorism. And while it also included the collection of information about, quote, forms of threats to the national and cultural historical identity of Serbs who live outside of the Republic, close quote, of Serbia, it clearly sets the legal boundaries of what Mr. Stanisić's organization was entitled to do: collect information. Let me now speak directly about Mr. Stanišić and his place in the Ministry of Internal Affairs. Slide 9 contains a brief summary of his professional appointments. Jovica Stanišić would join the MUP in 1975. His first position there would be in the State Security Service, the DB. Although throughout 1991 Mr. Stanišić was nominally the deputy head of the DB, the evidence in this case will show that during this period, the de facto head of that, he was also the de facto head of that organization. On the 31st of December, 1991, with Slobodan Milosevic's intervention, he assumed the position of head or chief of the DB. As you can see from slide 10, Mr. Stanišić had the responsibility of implementing the mandate of the Serbian DB. I would also like to point out the penultimate paragraph, quote, organizes the execution of tasks and affairs within the competence of the division in conditions of emergency. Sorry, Your Honor.
Mr. Groom, it's common experience that when you're reading that you speed up. The French interpreters were at least a couple of lines behind, so I'd like to invite you to slow down.
I will, Your Honor. Thank you. I'd also like to point out the penultimate paragraph, quote, organizes the execution of tasks and affairs within the competence of the division in conditions of emergency, imminent threat of war, and war, end quote. Although there was conflict in Croatia and Bosnia from 1991 until 1995, Serbia itself never, ever declared a state of emergency or imminent threat of war, and thus this paragraph never became effective during the period of this indictment. Let me now turn your attention to the career of Franko Simatović. Slide number 11 is a brief summary of his resume. He would join the DB 3 years after Stanišić in 1978. He worked in the section responsible for gathering intelligence. As you can see from this description of Mr. Simatović's job on slide 12, he was primarily charged with implementing projects to gather intelligence, data, and information about threats to Serbia. While the mandate extends to collecting information about perceived threats to ethnic Serbs living outside of Serbia, it does not provide for any forcible intervention outside the country. The internal laws of Serbia are laws similar to other modern states, laws designed to circumscribe the activities of a governmental organ with precision and maintain a balance of power.
Mr. Groom, I have to repeat my request.
Okay. They are there to ensure that the authority of the state is not misused. While ideologically, Stanišić and Simatović identified with Slobodan Milošević and his goals for the Serb people, the laws of Serbia prevented them from deploying their personnel as a fighting force outside Serbia's borders in Croatia and Bosnia. When Croatia and Bosnia-Herzegovina declared independence, the presence of the Yugoslav army there was no longer legitimate. It became necessary for Milošević to create a paramilitary force that could be deployed covertly outside Serbia and outside Serbia's laws. A paramilitary force that could be used in combat as well as in the commission of the crimes necessary to implement Milošević's goal of creating ethnically pure areas in Croatia and Bosnia. The State Security Service, already engaged in covert operation gathering, was a logical place to create such a special unit. If the state is going to engage in criminal conduct, it will use its secret services to engage in that conduct.
Your Honor, at this point I raise with hesitance, but is it the personal opinion of the prosecution we hear, or is it an opening statement without argument? It is improper in an opening statement to argue a case on the basis of personal opinions and views of the prosecution. So I object if this is an opening statement whereby the prosecution presents its personal view on the relationship between the accused and Mr. Milošević and the DB and their goals or their policies. An opening statement is meant to present what the evidence will be presented by the prosecution. It's not meant to be an argument. It's not meant to be to provide the personal opinion of the prosecution.
Mr. Groom, did you intend to do anything else than to tell the court what you will establish by presenting your evidence, or do you go beyond that?
No, Your Honor, the two things that I believe I'm charged with here is letting the Chamber as well as the accused themselves know what the theory of the prosecution case is, as well as give an overview of the evidence. And those are the two things that I intend to do, nothing else.
So what you're telling us is what you intend to prove and what is underlying your case?
Yes, Your Honor.
Mr. Knoops, I do not see that there's anything wrong in that, is it?
Well, maybe then the prosecutor should, for the defense's sake, differentiate between what the evidence is going to say and what the view is of the prosecution theory.
Yes, the two are intrinsically intertwined, I would expect.
And Your Honor, I would note that all of the evidence is clearly marked, as you'll see in the slides, with the 65 turn number. So the defense will be very clear to the defense what is specifically evidence and what is the theory of the prosecution case.
You may proceed. At the same time, you're invited to keep in the back of your mind what apparently is of concern for Mr. Knoops. Please proceed.
Your Honors, throughout the course of this opening, the prosecution will introduce you to some of the people who are central to this case. Each of the people we speak about in this way is a core member of a joint criminal enterprise with Mr. Stanišić and Mr. Simatović, or were prominent members of the special units of the Serbian DB. One of the people the Chamber will hear a great deal about is Slobodan Milošević. It has always been the position of the Office of the Prosecutor that he was the central driving force behind this joint criminal enterprise. The prosecution will tender evidence in this trial showing the close working relationship that the two accused had with Mr. Milošević. In October 1998, when Stanišić was dismissed by Milošević, he gave a public statement. In that statement, shown here on slide 13, Stanišić states that he executed his duties within his constitutional and legal powers. The Chamber's adjudication of this indictment will test the accuracy of this statement. He also made clear that he had aligned himself with President Milošević in the early 90s. A careful examination of Serbia's law at that time will make clear that such an arrangement circumvented the legally defined chain of authority. Mihail Kertész, like Jovica Stanišić, was born in a place in Serbia called Bačka Palanka. He was the head of the security department in one of Serbia's largest banks, the Definment Bank, and secured the financing for Jovica Stanišić to create the special units of the Serbian DB. I would like to play an intercept for you. The translation is on slide 14. And we hear Kertész and Karadzic talk about the problems Mr. Stanišić is having with his lawful superior, a person by the name of Mr. Janašković, suggesting that Milosevic's trust in Janašković was misplaced.
za svaki posao on pita. Ne, Sloba je dao odrešen ruke Jovici i meni. Međutim, on je Jovici šef i on Jovicu raspamećuje. Ne da mu baš ništa da radi. Jovica je zbudio, danas me 2 puta zvao i ne može zamisliti danas 50 komada su radi i tu 5 sati mu pustio.
Mr. Groom, we read it in English. The audio is just in BCS. We have no French translation of it, so we have an incomplete record.
Your Honor, I had provided all the booths with the text, but I see now that I admit to have provided them a copy with the slides. I'll do that as soon as I can so that they have the text that they can work from as well.
Because this is just for informing the parties. If any audio is played or if any video is played with sound, then I expect the parties to provide in advance a transcript to the booth so that the booth can translate into the relevant language the text spoken. Now sometimes the speed of speech is such that it may be difficult to translate, and then the booth are invited that one of the interpreters follows on the text whether that reflects the words spoken, and that the, if I could say, the teammate would then translate on the basis of the transcript, which finally results in a complete record where we have the original and the relevant translations. Please proceed, Mr.
I'm going to ask if the usher could provide to the French booth a copy of the slides in the event that they're unable to read it from the screen. An electronic copy is also being sent as we speak. Your Honor, we heard in this intercept Kertész saying that Milosevic had given him and Mr. Stanišić carte blanche. I would like to show you a clip from a video we referred to several times in this opening. The video was taken during an awards ceremony at the Radoslav Kostic Training Center in Kula, Serbia, in May of 1997. Many of the people who were behind the formation of the special units of the Serbian DB and supported its activities in Croatia and Bosnia attended. During this clip, Jovica Stanišić is giving Milosevic a tour of the facility and handing out awards to those who played a prominent role in the unit.
Before we play it, can I just verify with the booth whether the system is now in place?
The interpreters note in the English booth the system is not in place. We don't have the text and the screen keeps flashing on and off, E-court screen, so we can't read it. Thank you.
Written copies should be provided to the booth, and I share the... my eyes are moving quickly as well.
Your Honor, I see my own screen is flashing. We came down yesterday evening after court to test that there would be no problems, and I was told that there were no problems. I'm not sure what has happened today. I have another copy, Your Honor, that we can provide the English booth.
Then we wait until it has been provided to the English booth, and then everyone's... Yes. The usher is busy copying for all the booth, so we have to take our time. Otherwise, we are...
Your Honor,
yes.
If I might, as assistance, I provided 6 copies for the chamber. If all of those copies are not in use, well, I think...
My copy is available at this very moment for the English booth, and
we'll...
We have the text. Thank you very much.
Yes. Could someone give it to the... could perhaps... If everyone stays in this courtroom, they'll never be received by the booth. I'm not criticizing anyone, and the last person I would expect to do it would be... our registrar.
Your Honor, while that's being done...
Mr. Groom, under those circumstances, I expect one of your team members to immediately receive that and give it to the booth, instead of making the registrar leave the courtroom and do the job.
Yes, Your Honor.
Which easily could be done by, I see you're two young, strong men, isn't it?
Yes, Your Honor.
Yes. Yes. The matter has been resolved. Are all the booths ready? Then the video can be played. Please proceed, Mr. Groom. To be quite honest, I don't hear anything at all.
Your Honor, I hear some squealing sounds. I mean, as I've told the court, we were down here last night to ensure that there would be no problems. If the director needs a break to resolve a technical problem, if he could advise us of that. But all of our tests have proven to leave us still with some kind of technical problem. We did not have this problem last year. We attempted to ensure against any unforeseen problems last evening.
Mr. Groom, I suggest that we take the break now, that there can be done a lot of more testing, and then we resume at 25 minutes past 5, and then you can continue until 7.
Thank you, Your Honor.